Hello, everybody. Welcome back to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. Today is Friday, November 15th, 2024, and I wanted to go over the Brunson Brothers case specifically. I know I addressed it in my show earlier, but I wanted to show you guys something. I missed it. I was going to show it to you. So I'm just going to make this a standalone on the Brunson case. All right. I just did a search orders to seal records in court cases. This is what it came back. Orders to seal court records. In court cases, orders to seal records are issued to restrict public access to certain documents or information. This is typically done to protect sensitive or confidential information, maintain witness anonymity, or prevent harm to individuals involved in the case. Here are the key aspects of orders to seal records. Request for sealing. A party may file a motion or application to seal records, accompanied by a memorandum and declaration outlining the facts justifying the sealing. Service. A copy of the motion or application must be served on all parties that have appeared in the case unless the court orders otherwise. Redaction. Unless the court orders otherwise, parties already with access to the records to be sealed must be served with both a complete unredacted version and a redacted version. Court discretion. Judges have the discretion to grant or deny requests to seal records, balancing competing interests and stating reasons for their decision in a written order. Scope and duration. If a judge grants a request to seal records, the scope and duration of the order should be the least restrictive and most temporary possible. Types of cases where records may be sealed. May, right? It's not mandatory. Cases involving witness protection information. Juvenile cases such as child sex offense or custody cases. Adoption or paternity cases. Debt collection or dissolution of marriage cases. Protection order cases. Procedural requirements. A written request to seal records must be filed by a party affected by the release of information in the court record. The request must be verified, and notice must be provided to parties and others directed by the court. The court must balance competing interests and state reasons for granting or denying the request in a written order. California specific information. Federal court guidance. The Federal Judicial Center has issued non-binding guidance to minimize improper sealing of court records. The public's right to access court records is not absolute, but a judge must make an explicit determination that the right of access has been overcome before sealing records. The test for sealing is strict, requiring overriding interest justifying secrecy and a narrowly tailored sealing order. So let me get over here to the Brunson Brothers case per se. This is Lois Brunson's cases. As you see, they are closed right over here. The first one, July 12th, 2021. This one lasted a month. 6/2/2021, 7/12/2021. This one filed April 5th, 2023, closed July 21st, 2023, 3 months. This one filed March 23rd, 2021. It lasted to March 21st, 2023. Wow, that's a whole bunch of weird ass numerology right there. But anyway, here you go. Those are the 3 cases for Lois Brunson in the federal courts. Now we'll go over here and we will look up Raylan's cases. And again, we have all the cases filed by Raylan Brunson. And we have over here February 10th, 2022, closed. October 6th, 2022. Here's a bankruptcy that he went through from 2015, 2014. Here's another one from August 17th, 2023 to February 9th, 2024. Another one from August 5th, 2021 to February 2nd, 2022. This one, April 12th, 2023 to August 10th, 2023. There you go. Those are the filings for them. So let's go over here and let's continue, because we got to go look under every rock, right? Isn't that how we roll, Floyd? This is supremecourt.gov. There's the Brunson Brothers case, but there you go. I just did a search under the Brunsons. This is page 1 of 11. There's 52 items here. Obviously, it's not Jonathan Eugene. Here's Raylan Brunson. I could open all these up, but we just went through them. But I want to go over here and show them to you. So there's one on that page. There's one, at least one right here. There's another Lloyd Brunson. Here's Raylan's. Go to the next page. Go to the next page. And go to the next page. Next page. So I'm doing the research for you, folks. If you like that. Next page. Next page. Next page. Next page. And the last page. So we have 2 entries. So we'll go back to the first page. And here we go for Raylan Brunson. And we'll just scroll down right here. It was docketed April 2nd, 2024. Decision date, February 9th, 2024. Proceedings. Go down here, July 22nd, 2024. Rehearing denied. Petition for rehearing filed. Petition denied. Petition for writ of certiorari. So, bam, here it got denied by, let's see, Sotomayor, Kagan, Jackson took no part in the consideration or decision of this petition. So they recused themselves, because I believe they're defendants. So all the conservatives denied this, folks. That's what you're looking at. So they did a petition for rehearing. And the petition was denied. As you see, there are no more entries. So let's go back. Let's see. There we go. We're back on the Brunsons on page 1. We're going to go to page 2. And here's Loy's case. And as you see, Brunson versus Adams, docketed April 24th, 2023. Petition for writ of certiorari filed. Amicus brief of Paul Preston and New California State not accepted for filing. Brief amicus curiae of Paul Preston et al. Filed. So they accepted it 3 days later. Waiver of right of respondent, Alma S. Adams. Petition denied, June 26, 2023. Petition for rehearing filed. Petition for rehearing denied, August 21st, 2023. So if any of y'all know anything about time limits are expired on these cases for any further review. That's a wrap. That's a stick a fork in it. So if there were going to be sealed records, you would see it on the docket. You would see the motion. You'd see the judge's order. If there was going to be an NDA signed, you would see that as well. Because all parties have to come to an agreement, because this is a commercial process under civil rules and procedure masquerading with whatever the hell they label it. That's what's happening, folks. Most people don't realize that and understand that. So I wanted to break this down for you for the Brunson Brothers case. TVET, no NDA. The only time NDAs are signed in a courtroom is upon the agreement of all parties, and it's generally done between the two opposing parties. And it's usually behind, some type of settlement, like a corporation, where they often come out, oh, we're not going to accept responsibility, but we're going to plead guilty to the offense. Clista. Floyd, I watched Dr. Scott today explaining the Brunson. Also, he stressed it is a personal damage claim, and the denied means nothing. You would have to watch it. As I watched him try to explain it on Mark Z. And, I don't know how much legal experience Dr. Scott has in the courts, but I know how much I have. And I've told you folks, okay, at one time, okay, in my life, I had pending litigation in the following courts, all at one time, all my own personal litigation. Okay, you ready for this? Harris County Criminal Law at Court number 8, the 351st Judicial District Court of Harris County, Texas, the First Court of Appeals in Houston, the 14th Court of Appeals in Houston, the Texas Court of Criminal Appeals, the Texas Supreme Court, the U.S. District Court, Southern District of Texas, Houston Division, the U.S. Fifth Circuit Court of Appeals in New Orleans, and the United States Supreme Court in Washington, D.C. That's me, personally, my own litigation, all at the same time in all those courts. Now, somebody wants to come on here and debate me about law, we go round and round and round and round. I know how it all works. That's why I'm doing this video, to explain this is how it really works, folks. You can listen to all the gum bumpers over here. They just bumping their gums. I watch these legal analysis on these news channels. I was just like, what a joke. Because facts are facts. That's it. Robert, they still going to hang, though. Yeah. He brought up the Brunson videos today. Yeah, he played the same ones on Mark Z. He's trying to make it a point. I have no idea why. It's just there's no there. If he can point to a there where I can go see it and not somebody's unsworn statement, because that's what is somebody's unsworn statement? Hearsay. Hearsay is inadmissible. So we'll just cut to the chase right there. Because that's all it is hearsay. Unless it's, I declare to tell the truth, the whole truth, nothing but the truth, so help me God. Unless it's done under that, it's hearsay. And let me address that. Brunson said yesterday on PPN that the case was shelved by the Supreme Court and could be unshelved at any time they desire and ruled upon. Any judicial officer, okay, you're going to find this in most state laws. Any judicial officer who becomes aware of a violation of the law has a duty to take action. Any judicial officer. They're on the Supreme Court, Court of Appeals, District Court, state level Supreme Court, or a criminal appellate court, or a district judge, or even a justice of the peace, all the way down to the magistrate judges in the traffic courts. They all have a duty when they are informed or have knowledge of a criminal act to take action. So, can a court unshelve a case? Absolutely, they can. But those cases, they're dead. I'm just sad to say what I would like for them to be reality and they're true and all that's going to happen and Congress is going to disappear and they're never going to be able to hold political office again. Man, that would be glorious, wonderful. Well, I have to fall back on my own stuff. Well, damn, Floyd, what have you done? Oh, I filed the sworn affidavit of treason against the state of Texas pursuant to Article 1, Section 22 of the Texas Constitution, along with Minister Jesse Henley. And we went and got it notarized, and we sent a copy of that affidavit with all the criminal suspects listed, which is the Biden administration, and a bunch of rhinos. And we sent it to Greg Abbott and Ken Paxton and Ted Cruz and John Cornyn and Chip Roy. And I can sit here and go down and list all these people who are supposed to, by law, take remedial action, but never even called me. Never even said, hey, what did you send us? What is this? Is this a for real thing? Are you really making a bona fide, valid complaint of treason? Because if you are, then wow, we need to do something. Nope. I'm just relaying you my own experience, what's going on. I mean, people can sit here and try to talk stuff. Yeah. Oh, yeah, they could unshelve at any time. Well, that's putting hope in people's future that doesn't exist. He should never say anything like that. Is it a possibility that the Supreme Court could reopen the case on its own volition? They have that authority, yes. Is it a possibility that they're going to do it between now and January 20th, 2025? If they haven't done it yet, they're not going to do it, folks. Why would they let the crazy go insane, take over our country, run it into a shithole without taking remedial action? I mean, none of this makes logical sense that people would deliberately look away while all this criminal activity is going on because, oh, we're just waiting on the future. We're waiting for everybody to wake up. Well, everybody was awake the whole goddamn time. Problem was, we didn't want to say anything. We didn't want to go petition our grievances peaceably assembled, because what do? They're still trying to put those people from that first month of the year on the day after the 5th in jail. Just a report today about it. Nobody wants to be torn from their family. Nobody wants to go to jail or prison, or you have to go through any of those legal machinations. That's why everybody was just being real quiet and calm and praying to God. Everybody got out and voted and made it too big to rig. And that's what happened. And I don't know why people want to continue this fantastical theory, because it's a theory, because there's nothing to back it up. There's no holding by the Supreme Court. Even the conservative court justices refuse to act on it. You would think that they would be the ones that would lead the charge, right? Just look at reality. Y'all are not looking at reality. Y'all are listening to hearsay. You're listening to people that you think you should trust, and they're just blowing smoke up your ass. I'm sorry. I'm showing you facts. This is a finding of fact. Now I'm concluding law. That's why I show you what the law says. What is mandatory that everybody has to do to cover their own ass. Okay? If they're going to seal records in a court, they want you to know they sealed those records in the court so they're protected. So they're not doing anything. What? There's a term for that. Ex parte. It's Latin. You want me to look it up? I just happen to have the Black's Law Dictionary. Okay? That's when the opposing party goes and talks to the judge without your knowledge, and you're the other party. That can't happen. That's ex parte communications. Here we go. Ex parte. It is Black's Law Dictionary, 6th edition, on page 576. Ex parte. On one side only, by and for one party, done for, in behalf of, or on the application of one party only. So there can be no ex parte communications. Everybody has to know what the hell is going on. You have to play fair. There would be a motion to have it sealed by the government, right? If that government was going to do that, or even by the court. The court can issue its own motions. It can grant its own motions. But the reason it did the motion is to make everybody aware. We're going to have a hearing. Come tell me your side. You come tell me your side. Guess what? I'm going to find facts, conclude law, ask the judge, the administrator, and I'm going to issue my ruling, my opinion. That's Law 101 today. This is not legal advice, financial advice, or medical advice. So, please. Y'all can continue to believe the hearsay. And I'm telling you what it is. It's hearsay. If nobody's going to stand up and give you sworn testimony, it's hearsay. It's not truth. It's fantasy. It's just like conspiracy theories, that we know as suppressed facts. So I just want to give y'all a little bit of education so y'all can continue with your life and have the ability to disseminate stuff you hear and see and read and watch. So you can make an educated determination about the information coming into your head, whether you should keep it in here or just let it go right on by. And don't retain it. Don't think about it. Let it go. It's tough, folks. I know we all would like the fantasy, but sometimes it's just a fantasy, That's why they sold, so many Playboy magazines and Penthouse magazines, because of the fantasy. The guys who bought them thought that they were going to be able to sleep with those women. Well, everybody else but me. Not kidding. Not. So there's your Brunson Brothers update. I believe they have signed an NDA. Not unless they signed it with the Department of Justice, the Solicitor General, right? Let me go look real quick who was representing them. Raylan, Judge. This one doesn't tell me. Doesn't tell me who represented the. Or is it this one? Oh, yeah, it's this one. Here we go. Let me go show you guys what I'm talking about. So because we're going to go find facts and conclude law right here. Attorney for the respondents. And this would be Elizabeth Prelogar, United States Department of Justice. And you see here's a Lloyd Brunson, attorneys for petitioner. Here's another counsel of record who obviously is representing somebody in this case. I don't know who. Oh, Paul Preston. That's who. But there you go. Unless she presented this, which would be Biden's Department of Justice. Now I want you to put that math problem together in your head. Is Joe Biden really going to come out there and say, "Oh, we got to have you sign an NDA"? How much sense does that make? There you go. And the NDA won't go, it's not going to be on the record. The NDA is going to be predetermined, pre-agreed upon before the adjudication by the court. That's part of the settlement agreement. That's when the two parties get before the judge and, hey, if y'all got everything worked out, y'all satisfied? Good. Case over. And they move on. Everybody has a good day. Now in the back room or at their conference at one of the law firms, they're all going to meet, sit down. They're going to do what all they need to do. And then they're going to move on. Case over. Now, if one of those parties reneges on their agreement, their meeting between the minds, then they can go back into court, reopen the case, and proceed further because the parties were disingenuous. They had bad faith. Oh, let me read that. I was going to cover that earlier. I want to read a couple things to you. Things that we should all strive daily to achieve. Integrity, Black's Law, page 809. Integrity, as used in statutes prescribing the qualifications of public officers, trustees, etc. This term means soundness or moral principle and character, as shown by one person dealing with others in making and performance of contracts, and fidelity and honesty in the discharge of trusts. It is synonymous with probity, honesty, and uprightness. A bunch of stuff in here. These are terms that I often use. So this is good faith. Good faith is located on page 693. Good faith is an intangible and abstract quality with no technical meaning or statutory definition. And it encompasses, among other things, an honest belief, the absence of malice, and the absence of design to defraud or to seek an unconscionable advantage, and an individual's personal good faith is concept of his own mind and inner spirit, and therefore may not conclusively be determined by his protestations alone. And that is a New York State case. The next line is honesty of intention and freedom from knowledge of circumstances which ought to put the holder upon inquiry. An honest intention to abstain from taking any unconscientious advantage of another, even through technicalities of law, together with absence of all information, notice, or benefit or belief of facts which render transaction unconscientious. In common usage, this term is ordinarily used to describe that state of mind denoting honesty of purpose, freedom from intention to defraud, and generally speaking, means being faithful to one's duty or obligation. California Appellate. That's why I use these terms a lot, because they have meaning. Good faith, integrity, and clean hands. Clean hands doctrine falls on page 250 of the 6th edition of Black's Law. Clean hand doctrine. Under this doctrine, equity will not grant relief to a party who, as actor, seeks to set judicial machinery in motion and obtain some remedy if such party in prior conduct has violated conscience or good faith or other equitable principle. That's a Missouri case. One seeking equitable relief cannot take advantage of one's own wrong. There you go. Very applicable to what's going on with Jeff Rahm and why he potentially may not be back on the show. Somebody was operating with unclean hands. Bad faith, lack of integrity. I can go into honor, but everybody knows what honor means. So that's how I roll, with honor, good faith, and clean hands at all times. I strive to be the best I can be, to give you the best information, the most concise, succinct, and facts where I can go, here it is, folks. Go read this for yourself. I'm not making anything up. I'm not going over here listening to so-and-so and I'm relaying so-and-so's information that I have vetted. I haven't vetted. I don't know if it's true or not. And it's not a sworn statement, so it's all hearsay. That's what you're getting here. Like it or not. Subscribe, hit that notification bell, leave a comment below. Thanks for being here. Again, I hope I gave you all a little something about the Brunson Brothers case and how the records are sealed and NDAs and how all that works and what it looks like and how you should achieve to strive to operate with honor, good faith, clean hands, and always with integrity. Thank you, everyone. Go make America great again. The link to the mushrooms is down below. It is Fearless Floyd Pets. FearlessFloydPets.com. Go there. I know it's pets, but the mushrooms are for humans as well. If you'd like to email, it's down there below. FearlessFloydPets@gmail.com. So go check that out. If you haven't voted for my friend yet, Dr. Ed Group, please go over here and vote and help Ed get nominated to RFK's. The link to do that is below. You're going to have to register with RFK's Junior's website. Once you create your little profile, go in there, give Ed a comment, give him a like, and give him a vote. Put somebody in there that you're just 1 degree of separation from, like that. where you can clean up your food, your beverages, your land, your air, your soil, your water, your food, your beverages, your restaurants, your grocery store, your convenience store, your skies, your mind, body, and spirit. You're getting the picture now. Thank you, everybody. Don't forget to go vote. I know. Oh, yeah. And it's not over. So 2026, look forward. Don't let it go. Definitely if you're in South Carolina, y'all need to get right now moving on Lindsey Graham. Y'all need to get the guy out of there. Because if they can't get term limits, he's got to go. We need to find somebody that has the stamina and integrity, honor, and good faith to replace him. Who's not going to be wishy-washy and be able to, go launder money overseas, allegedly.